how do we improve the property tax appeals process? Top 10 suggestions, although if you keep count, there are only really 9, so let's get at it. Number one is to deal with the problem of the first tier tribunal in property tax appeals at the Board of Equalization Review, without impugning in any way the integrity and the good efforts of our county commissioners. We have built a structured, hardwired system that inherently creates a conflict for county commissioners who, on the one hand, are responsible for the fiscal affairs of the counties, and on the other hand, are asked to be the judges of whether or not an assessment that may produce millions of dollars in taxes and is being challenged can provide fair judgment on that. He might have been speaking of that problem when Jesus said, "No man can serve two masters, for either he will hate the one and love the other, or else he will hold to the one and despise the other." But that's exactly the situation we have here. The problem is not bad at the level where somebody comes in and talks about the value of his house, or his carport, or his motorboat. But where an industrial citizen comes in with hundreds of millions of dollars in property in the county, whether they're coal or manufacturing, and says that we've got an issue here that is going to result in a $750,000 adjustment to our tax bill, it is almost impossible for a county commissioner not to look inside and say, what's this going to do to my efforts to pass a budget this year? I had one commissioner comment to me from the bench, said, Mr. Rose, do you realize how many feet of water line we can run up at Pond Gap with the amount of money you're asking us to forego? And I said, well, that's not what we're supposed to be doing here. You're supposed to be giving an impartial first level hearing. But we have that inherent conflict, and it is very serious with regard to large property owners. We also have a problem that's been a result of a Supreme Court decision where they have imposed a standard of proof on a taxpayer to prove that the assessment is incorrect by clear and convincing evidence. You know what preponderance of the evidence is. That's a civil trial where $100 million in judgment in damages may be involved, and the jury is told if the plaintiff is just 51% more credible, then you find in favor of the plaintiff. Standard of proof is, in a criminal case, is beyond a reasonable doubt. Judge Cletley used to describe that as saying, if you look out the window and you can't see the rain, but everybody on the street has his umbrella up and every car that goes by has his wipers on, you know beyond a reasonable doubt that it's raining outside. Okay, but clear and convincing is a greater standard of care of proof than preponderance, which we're used to in civil litigation, and lower than beyond a reasonable doubt. It is a substantial. And so a finder of fact could find that the property owner had prevailed by a preponderance of evidence, but still find against him because he hadn't prevailed by clear and convincing. We think it's not the appropriate standard for this sort of thing. It is the appropriate standard when relief is asked for. As an example, the state taking a child out of a home or eliminating parents' rights to have the child. That is something other than money. And we think that this is not something other than money. These are tax dollars that are in dispute. We have now for a long time had case law decisions from the Supreme Court that require property owners, regardless of the size of their issue, to essentially produce a fee appraisal if they're going to challenge the assessor. In the old days, it was not uncommon for a homeowner to come into the county commission and say, look, I built this myself, I've paid $50,000 for it, you've got the improvement on it $100,000, it's too high. Today, when it's enforced, that's not permitted. He'd have to have something which the Supreme Court says is the equivalent of a professional fee appraiser, which is unaffordable in most cases for people who are dealing with their house values, their carport, their motorboat. Obviously, in an industrial appraiser where we have hundreds of millions of dollars in property at stake, obviously there's always going to be a fee appraisal. But for the low-end appeals, it's a great, great burden and discourages people from bringing those claims that they should. I say this, the Supreme Court made it impossible for taxpayers to win their cases by making a clear and convincing standard of proof, but they were fair. because then they turned around and made it impossible for the assessors to prove their case by requiring that when a taxpayer comes in and challenges the value, they have to go through a litany of about 20 factors that are included in one of the commissioner's legislative rules, and be able to testify that, yes, I did consider the topography. I did consider this very, and yet, because of the automated system we have now, no assessor does it that way. And when they're put on the witness stand and put under oath and examined by the taxpayer's lawyer, saying, did tell us what you went through when you looked at the topography of this property and what effect did it have on your opinion as to value? They're hard pressed to do that. It makes it impossible for the assessor to do it. We have a problem with the, again, court-made law of the burden of proof, the standard of review, rather, that's provided to the circuit court. Go to the Board of Equalization and Review, make your record there. Senator Gonch, those are important proceedings because your entire case is based upon the evidence that's produced at the Board of Equalization and Review. There's some adjustments now, thanks to 2012 amendments, but nevertheless, basically you're stuck with the amount of the testimony and the documentary evidence you get in from the Board of Equalization and Review. And the Supreme Court has said that the county commission, or the circuit court rather, even if they think that the assessment's too high, still has to affirm unless the decision of the county, of the Board of Equalization was clearly erroneous. Even if they think that it was wrong, unless it's clearly erroneous, they have to sustain. There are problems on occasion, much less of a problem now than it used to be, of adequate time for a taxpayer to present his case. It's a two-factor issue. One, you have a limited number of days in October and in February in which the board sits either as a Board of Equalization and Review or a Board of Assessment Appeal. And in some cases, it's as little as 15 days a year. That's pretty much the minimum amount they have to sit, and a lot of counties do that so as not to, well, whatever their motivation is. And the other axis on that is that sometimes the docket gets filled up and the county commission has to put a limit on how much time you have before them. Now, I've had county commissions take us to midnight and be extremely generous with time and work hard like you all are working this morning of going over, but they can say, okay, you've got 20 minutes. And basically what you do is introduce your appraisal, and that's pretty much your 20 minutes. So that's a bit of a factor. We also have a situation where the assessors may not be bound by a circuit court decision for subsequent assessments. And by that I mean that we go in and litigate the value of an office building in the downtown. The assessor says it's $5 million, the taxpayer says it's $1 million, and the circuit court finds that it's a $5 million, it's a $1 million property. July 1st rolls around again, the assessor says, I still think it's worth $5 million, and puts the property back on at $5 million, which then requires the taxpayer to go back to the circuit court and do it again. The circuit court says, no, I said $1 million. I said, okay. July 1st of the next year rolls around. The assessor says, I believe the property is worth $5 million. And that's an experience that I've had for a taxpayer in a sophisticated county, in a very sophisticated county. So that's a problem. That's a problem. The common view is that every year is a new year, that properties can all be reevaluated every year, and therefore the previous year's value is not necessarily binding on the assessor for the subsequent year. Then we get into what we've talked about a little bit, I've heard you say. We have a separate appeals process for valuation. Actually, we have two separate assessment appeals process for valuation. One, the Board of Equalization and Review, which is the old-fashioned one. The new one is the Board of Assessment Appeals, which was passed in 2012, which sits in October, gives you more time, has some discovery, may be able to go back and reopen the record, but that's for valuation. We have a separate system for issues regarding taxability and classification. Taxability, is it taxable at all? Is it exempt from property taxation because it's subject to the Freeport Amendment? That's a very common litigation. Classification, is it Class 2, as Mr. Carl was talking about? Is it in Class 2, Class 3, Class 4? Those are not dealt with through that. That goes to the assessor and then directly to the tax commissioner. County commission is not involved in that issue at all. But they're two separate processes. On top of that, as has been noted earlier this morning, we have an entirely different system for public utility properties. That bypasses the county system altogether. Goes to the Board of Public Works. Somewhat of an archaic board. I don't want to say it in front of any of the members, but a whole lot of what the Board of Public Works used to do, they don't do anymore. Namely, they don't get to write the budget.